recording for everybody's information. And so even though we haven't started officially yet, there is a recording being made of this meeting. We can get started here in a few minutes. Trying to think if there's anything else. Yeah, we only have limited number of viewings available, as Mr. Bromer has kind of pointed out, with the way Microsoft Teams works, but it's what the state provides, and so here we are. At this point, I guess, let me make a few online meeting of June 25. I'm just making the standard notes that I make anytime we have a meeting. I guess since we are all here in some manner or form, at least all what I would consider to be, as I said, the critical people, I will now ask Chairman Bromer to call the meeting to order and take it from there.
All right, Phil, thank you, and good morning, everyone. I would like to call the June 25th, 2020 meeting of the Ohio Election Commission to order. Before we get started, I'd like to say a couple little things, and one is, this is a first for the Ohio Election Commission to have a virtual meeting. Now, we all know that technology is wonderful, and let's hope it applies today. So far, so good. The other thing, as Phil mentioned, and I'll just echo it, the proceedings will be videoed, so that will be taken care of by Phil. And I guess at this time, Mr. Richter, I would like to ask you to take a roll call of the commissioners.
I will gladly do so. Ms. Cunningham?
Present.
Ms. Kaufman?
Present.
Ms. Taveras?
Here.
Mr. Kreitz?
Here.
Mr. Norman?
Here.
Mr. Beatty?
Here.
Chair Bromer?
Here.
I think that accounts for everyone.
Yes, I would say let the record show that all commission members are present for this hearing today, for this meeting today. Additionally, anyone who is going to address the commission today, would you please identify yourselves?
I'd say, Derek, go ahead first, because you'll be going first, and then Ms. Justice can identify herself. At least I presume, as we discussed the other day, I think those are the only two that are going to address the commission.
Yes, that's correct. That's my understanding as well, at least. My name is Derek Klinger. I'm an attorney with the law firm McTighe & Colombo, and I represent the complainant, John Stafford, who also is the one who filed the motion that is pending before you all today.
All right, thank you. I should say for the record that the case.
Well, Ms. Justice, did you want to go ahead?
Oh, I'm sorry.
Good morning. My name is Tabitha Justice. I represent the Bellbrook Sugar Creek Local School District Board of Education in the matter currently before the commission.
All right, thank you. Sorry, I interrupted. I would like to say for the record that the case we're going to discuss today is case number 2019 G-015, Stafford versus Citizens for Bellbrook Sugar Creek Schools. I would also like to say for the record that prior to today's meeting, all commissioners received memorandums from legal counsel for both the complainant and the respondents detailing their respective positions. Having said all that, I would now like to turn the meeting over to our executive director, Mr. Richter.
Thank you, Chair Bromer. Just as a brief recap, and hopefully everybody can hear me, this case was brought by Mr. Stafford, and it alleges certain campaign finance violations by the campaign committee for the passage of the Bellbrook Sugar Creek School Levy from May of 2019. It was brought against the levy committee and its chair and its treasurer, Mr. Kozad. Obviously, Mr. Stafford brought it. So that's the overarching issue. It's primarily related to whether there are improper in-kind contributions that were not properly reflected by the campaign committee. Yeah, you can take whatever, but please don't come in otherwise. Okay. Anyway, there's a gentleman at my door. I'm not sure why. Anyway, there were subpoenas requested by the complainant's counsel, Mr. Klinger, that were issued by the commission. There has been controversy over whether they have been satisfactorily responded and replied to. I took certain action in February on 2 different occasions to hopefully give direction as to what needed to be provided, how it needed to be provided, etc. I think it's safe to say that from Mr. Klinger's perspective, that was not that subpoena was not properly complied with, and so we find ourselves here today on the motion from the complainant to compel production or compel response to the subpoena to potentially impose some sort of a sanction and potentially even to initiate a proceeding in the Franklin County Court of Common Pleas to enforce the subpoenas. That is the motion that is before us today. Mr. Klinger filed the motion. Technically, Mr. Subashi signed, but on behalf of both he and Ms. Justice, a responsive memorandum was submitted to the commission last Thursday. I circulated, as Chair Bromer indicated, those materials were circulated to all commission members last week, so you have had them. So we are now here today to address this. The commission's rules empower the staff attorney and executive director, me, to do a variety of things to essentially move a case forward, to try and work with the parties, to come to a resolution on discovery, etc. That is what I tried to do in February. But if, as this motion has requested in terms of either further moving to compel, imposing a sanction of some sort, that is something that only the commission has the ability to do based on our rules which, they stand as they state in terms of giving direction. They also invoke the civil rules. So I believe we have all of those materials before us to use as guidance in this matter. And so that's why we have convened today for the full commission to hear the respective arguments from parties and make a determination on that motion as to whether it would be granted or not. And if it is, whether to impose a sanction or not, and what that sanction would be. I sent out an email yesterday to Mr. Klinger and Ms. Justice informing them that they will have 15 minutes to address their respective sides of the argument. I am about to indicate to Mr. Klinger that he will commence here shortly. If there are any other questions, I would encourage them to be asked now. But other than that, if there are no questions from anybody, I will ask Mr. Klinger to go ahead, indicate whether he wants to use his full 15 minutes or potentially reserve time for possible rebuttal. As I consider the 15 minutes, based on direction that I previously received from commission members, or one commission member at least, I'll take into consideration the nature of the commission's questions and the impact on the time, although I will try and hold to a strict 15 minutes. At the conclusion of the presentation by both counsel, it is then up to the commission to determine how it wants to proceed. Certainly, it has been what I would say is standard for the commission to make a determination on a motion right then and there. But it certainly would not be out of the, well, it would be out of the ordinary because this whole matter is out of the ordinary of sorts at this point. But the commission has the ability to take under advisement and hold in abeyance an actual decision and issue it at a later time, if that's what the commission decides to do. That will be addressed once the arguments and the questioning period is over. So if there are other questions, raise them now. Other than that, I'm going to turn it over to Mr. Klinger and ask Mr. Klinger to make his presentation on behalf of the complainant.
Well, thank you, Mr. Richter, Mr. Chairman, members of the commission. Again, for the record, my name is Derek Klinger. I'm an attorney with the law firm Nick Tigan Colombo, and I'm here today on behalf of complainant John Stafford, who again is the one who filed the motion pending before you all today. Now, this motion is about the enforcement of a subpoena issued to the Bellbrook Sugar Creek Local School District, and as Mr. Richter said, it is a subpoena that the commission, through the executive director, has already ruled on and said that the district must comply with. So the primary question for you all today is not, does the district need to comply with the subpoena? Because again, the commission has already said that they do need to comply with it. Instead, the primary question is, has the district complied with the subpoena? And the answer to that question is no, they have absolutely not complied with the subpoena. So I just want to talk about the subpoena here briefly. Subpoena contains 13 requests, but for purposes of this motion, we can split these 13 requests into two groups. One group consists of 3 of the 13 requests, and these are 3 requests that were modified by the commission's February 26th order, ordering the district to comply with the subpoena. Now, when I say modified, I mean, they were narrowed in scope. My client had offered to narrow them in scope, and that is what the commission ultimately decided to do, was narrow them pursuant to the terms offered by my client. Now, the other group consists of the 10 requests that were not modified by the commission's February 26th order. The order is silent with respect to these requests, and it does not purport to modify them in any way. Now, regarding the 3 requests that were modified by the commission's February 26th order, these are the only 3 requests that the district even claims to have responded to. Now, as I will explain in just a moment, the district did not respond to the other 10 requests at all. Now, how does my client know that the district did not fully comply with these 3 requests? Well, the district told us they didn't. The district produced a single document in response to these 3 requests, and when they produced these documents, the district told us that they had excluded 3 groups of documents from their production. They excluded public records they believed had been produced to my clients by other public entities, not the district. They excluded documents that they said were produced pursuant to other subpoenas, and they excluded documents that they said were already produced to my clients in a separate legal action that is pending in the Greene County Court of Common Pleas. Now, why are these exclusions a problem? There's 3 reasons for this. First, as a general matter, the commission's February 26th order did not allow them to exclude any documents. Instead, the order says that they have to produce any and all responsive records. Now, in response to this, the district in the brief they filed, they contend that the commission's February 14th order, so an earlier order, they said this allows them to exclude documents. But they are taking a quote from the order entirely out of context. Now, all the February 14th order really did with respect to the district is that it ordered the district and my client to provide more information to the commission so that the commission could make its decision about whether or not to quash the subpoena. Now, of course, the district, however, ignored this order. They failed to file any additional requested information when it was requested. And the result is the February 26th order that modified just 3 requests pursuant to the terms that my client had offered. The second reason these exclusions are a problem is that it appears that the district is using this as an opportunity to relitigate their motion to quash, which was denied. Again, that was denied. It was largely denied on February 26th, and now it seems like they are trying to get a second bite at the apple, and they should not be able to do this. Now, the third reason these exclusions are a problem is that even if the district was permitted to relitigate their motion to quash, there's just no justification for excluding any of these 3 categories of documents. First, they're all public records. As a public entity, the district is obligated to provide the documents. Second, with respect to the documents they say were provided by other entities, my client is seeking the district's records. He's not seeking other entities' records. So it's really irrelevant what other documents have been provided by other public entities. Now, they've said that they're excluding documents that were produced pursuant to other subpoenas, but no other subpoenas have been issued to the school district. So again, what relevance is this? My client is seeking the district's records, not others' records. And finally, they say that they've excluded documents that are already produced to my client in a Greene County court case. Now, just as quick background, my client has a pending lawsuit in the Greene County Court of Common Pleas against the Bellbrook Sugar Creek Local School District Board of Education. It is an Open Meetings Act lawsuit, an entirely separate legal action from this. Seeks different claims, different facts. There's really no overlap. And so as a result, the subpoena seeks entirely different information than discovery in this Open Meetings Act case. Now, the problem with relying upon discovery in this other lawsuit is that their discovery was filed under seal. My client cannot use anything from that case in this case. He, and I, for that matter, could be held in contempt of the court if we used any of those records that are filed under seal with the commission. And for this reason, it looks to me like the district is playing games with this. Because the records are filed under seal, I cannot tell you what that information is, and I cannot tell you what's in these records. So have they provided some stuff under seal? Well, that's really, there's nothing we can do about it. So I'm asking you to find that this exclusion is improper. And just to recap, with respect to this first group of subpoena requests, the 3 that were modified by the commission's February 26 order, again, the district admitted that they did not provide everything and that they intentionally excluded 3 categories of documents when they were not permitted to do so. So that brings us to the second group of subpoena requests. Again, these are the 10 requests in the subpoena that were not modified by the commission's February 26 order. The district flatly refused to provide any of these. They said they didn't have to provide any of these. But plain and simple, these 10 requests were never modified or quashed. The commission's orders are silent about these requests, and they were never even specifically in dispute other than the district's motion to quash the entire subpoena. But because these 10 requests were never modified or quashed, the district is obligated to provide the responsive documents, and they have not. And for that reason, they have failed to comply with the subpoena. So just to quickly summarize again, the subpoena contains 13 requests. The district has flatly refused to respond to 10 of the 13 requests. And regarding the 3 remaining requests, the district told us they excluded documents, and moreover that they filed some stuff under seal that we just cannot even use for this case as a result. So that brings us to the secondary question before you all today, which is, given the district's refusal to comply with the subpoena, what should the commission do about it? Well, first and foremost, my client wants the records. So we've asked the commission to do one of 2 things to force the district to provide the records. Either issue an order compelling the district to comply with the commission's order in the subpoena, or institute a contempt proceeding in the Franklin County Common Pleas Court. The second thing is I'm requesting the commission to sanction the school district for their conduct in the form of awarding my client his reasonable attorney's fees for pursuing this motion. Now, my client first requested the subpoena at the beginning of November, and here we are at the end of June, and the district has still not provided the documents. My client has gone to great expense trying to get them. We've made great effort to work with the district to try to get them, but they've refused to provide them, and it looks like they're playing games with this. So for these reasons, I'm requesting you to sanction the district for their conduct. Now with this, I'd be happy to take any questions, and otherwise I'd like to reserve the remainder of my time for rebuttal.
Well, just for the record, I timed that. He's got 6 minutes left.
Yeah, that's about what I would say as well. Anyway, any questions out there of Mr. Klinger at this point from the commission members? If so,
Yeah,
just go
I-
ahead and
I-
ask.
Yeah, I would like to ask you, Mr. Klinger, you're saying in your memorandum, you listed and you addressed that earlier in your remarks, 3 areas. And the first one was documents the school district believed were already provided by other public entities. You addressed that. Are you saying the information you requested that they claim you already have from other public entities, do you in fact have that? Is this an issue of you just want it from them?
Well, thank you for the question, Chair. I guess the answer is I don't know. So the reason this all arose is last summer, my client placed records requests with the school district. They took what I believe were unduly narrow interpretations of the public records law and did not provide us documents. So as a result, my client then placed records requests with other public entities because we believed that they would be in possession of some documents. And lo and behold, when we made these records requests, we actually obtained documents that, based upon what we could see, the school district would also have been in possession of these documents, but they did not give them to us. So what we've done here is, what we've seen here is that the district has previously withheld documents in response to my records requests. So based upon that, I'm guessing assuming there are additional documents that they have not provided.
Okay, thank you.
And I guess just to further clarify, because they're the ones in possession, I cannot say with any certainty what it is that they're withholding.
Yeah, Mr. Clerk, this is Mike Kreitz. I've got just 1 or 2 questions here. Since February, when you consulted and the executive director went ahead and issued a couple orders, what efforts, if any, have you made to confer with opposing counsel to attempt to effect a resolution of this?
Yes, and so even backing up, my client made an effort back in December to resolve this. Shortly after the subpoena was served in December, one of the district's attorneys reached out to me expressing concern that the subpoena was overly broad and that it would be too burdensome for them to comply with. Now, in response, my client offered to, first, I asked them to identify which of the requests they felt were overly burdensome and overly broad. They identified only 3 of the 13 requests, and in response, my clients offered to narrow those 3 requests pretty significantly. Now, in response, the district ignored this offer. They said nothing. They got no reply at all. About a month later, they filed a motion to quash the subpoena. Now, that motion to quash is what resulted in these February orders from the commission. Now, the February 26th order ordered the district to produce the documents by March 18th. Now, on March 18th, the district then sent me this email with the 1 responsive record explaining what they had excluded. And then for I'd say about 9 days after that, we exchanged emails. Myself and one of the district's attorneys exchanged emails trying to resolve this. That's kind of where we got to the point of it didn't seem like we could resolve it without the commission's further intervention, because they were saying that they could exclude these 3 records, and they were saying that they didn't have to provide the 10 categories of information that they're just saying they don't have to respond to.
If I could put that back up again, and this is Mike Kreitz. With respect to the issue of the public records, have you filed a mandamus action under 149.43 or filed a claim with the Court of Claims in connection with this? And are you asking us to enforce that? Because we wouldn't have the jurisdiction to enforce any kind of alleged violation of the public records law.
Thank you, Commissioner. No, I'm not asking you to enforce the public records law. And no, we've not filed the mandamus action. It just seemed kind of redundant considering that we have the subpoena outstanding to them. So no, to answer your question, we've not done that. But the fact is, these are public records, and so the district doesn't even have a valid reason for excluding them.
Thank you.
Okay. Anyone else?
I'm not sure this is appropriate, but I know there were also some discussions between council and our executive director about trying to resolve these discovery disputes as well. Can you tap into that for us?
I mean, my understanding is the discussions have been limited to what's in the February orders. So again, my client, or sorry, so back in December, again, when these subpoenas were first served, my client made an effort to resolve the district's concerns. Again, the district did not respond to that. That resulted in them filing the motion to quash with the commission. Now, after the briefing, the commission's executive director issued an order on February 14th. This order basically asks for more information, basically saying that the parties are basically saying opposite information. So I think the commission's executive director asked for more information in order to make his decision about the motion to quash. He ordered the parties to respond within so many days. I think it might have been a week or maybe 10 days. My client filed a response and the district filed nothing. They ignored the order. They did not provide any information. So I don't think they even were cooperating with the commission's order to provide the executive director with more information. And then that culminated in the February 26 order.
I would just briefly interject. Yeah, I've not really had any conversations with anybody. What I did was issue the two respective orders based on materials that I had received from respective counsel during that period of time in February. Okay. Anybody else have questions for Mr.
Thank you.
All right, that being the case then, let's hear from Ms. Justice at this point. And you now have 15 minutes, Ms. Justice.
Good morning. Again, my name is Tabitha Justice. I represent the Bellbrook Sugar Creek Local School District Board of Education. I have essentially three things to discuss with the commission this morning. First, the efforts that the Board of Education went to address and respond to the original subpoena. Second, the efforts the board made to comply with the commission's subpoena as it was limited by two orders from your executive director. Third, why even if the commission decides the board should reproduce the documents that it's already produced, or even do additional document searches, the board's actions can't possibly constitute the refusal to obey a subpoena under 3517.153. If you recall, the Board of Education for Bellbrook actually sought to intervene in this matter because all of the allegations in the case relate to alleged in-kind contributions by the Board of Education. Mr. Stafford opposed that motion. Because this case is essentially a standard complaint against a political action committee for alleged reporting violations, the commission concluded the Board of Education was not a necessary party. When the commission denied the motion to intervene, it meant that the Board of Education could not be subject to the broad civil discovery rules that apply to a party. It's not a party. Nevertheless, Stafford's attorney issued a broad subpoena to the Board of Education for everything it had related to the May 2019 levy election, even things that had nothing to do with the PAC reporting allegations in this case. The board filed a motion to quash, as been mentioned, or in the alternative, a motion for a protective order limiting document production to items relevant to the current reporting allegations. With that motion, the board included an affidavit from me as the district's attorney and an affidavit from Joshua Bowles, the school district's IT personnel. In my affidavit, I explained that the board had already responded to more than 200 public records requests from John Stafford and his attorneys, including requests for documents related to the 2019 levy measure. I specifically informed the commission that given the breadth of the earlier responses, I anticipated that there would be few, if any, additional documents uncovered in yet another search of district files. However, the burden on the district would be great, costing additional attorney and IT time. The affidavit from Mr. Bowles also explained that the subpoena was too ambiguous for a reasonable search to be conducted. He explained that a search for the word election, for example, would yield 64,880 emails. On February 14th, Mr. Richter stated he was not willing to allow a broad request if the information had already been provided to the complainant and can subsequently be provided to the commission by the complainant. In an order on February 26, Mr. Richter specifically stated, "It is hereby ordered that the following will be provided to comply with the commission's subpoena." He then set out 3 lists of emails for the board to provide relating to the May 7, 2019 election. Other than a list of people and entities, no other keyword search terms were provided. You have to keep in mind that school email search engines do not review the content of emails and categorize them by subject matter. To do a search, there must be keywords to look for. The board only knew May 7, 2019 election, which can mean obviously different things to different people. Still, given the circumstances, I wanted to be as compliant as possible, so I asked the IT personnel to broaden the search beyond what was set forth in the order to include the term levy. From a practical perspective, the election was about a levy, and people were more likely to use the word levy in an email than election. So the IT person, Mr. Bowles, for the district took all the people listed, ran separate searches for levy and election in May 7, 2019, based upon the time frame in Mr. Richter's February 26 order, and did those searches. As to category 3 of Mr. Richter's order, that was a little more complicated because that was just a list of government entities, not specific people. Again, no email system categorizes emails that way. The district personnel can't just say, "Hey Siri, please give me all the emails in the district from or to or anyone from the Attorney General's office." It doesn't work that way. So Mr. Bowles did the best he could. So Mr. Bowles did the best he could. He went to the website of each agency listed. So I think there's 5 agencies listed on here. He went to those websites and he found their underlying email domains, such as ohioauditor.gov. He searched for all emails to and from those entities. Then he had to narrow it down to the time frame in the February 26 order. Then he had to narrow it by the limited keywords that we had to search. So you can see, without more specific search terms or specific email addresses or specific emails to look for, it's difficult to conduct searches of electronically stored information. Here we'd already done that. Here we'd already provided them with the public records related to these searches previously. But this is why under Ohio's public records law, the courts have said people must request specific documents rather than broad categories of documents. Now, Stafford complains now that other requests were included in the original subpoena, and he talks about these other categories, these 13 or 10 other categories, but the February 26 order did not include those items. Again, that order said, "It is hereby ordered that the following will be provided to comply with the commission's subpoena." The board reasonably relied upon that statement and those lists in conducting its searches. If Mr. Stafford believed the order was incomplete, it was for him to go back to the commission to ask for clarification, not come after the district with the current motion. And it's also odd that Mr. Stafford complains that the board did not reproduce records that it has previously produced him in response to public records requests and in other litigation, when the original subpoena itself said excluding any public records already produced by the district. That's what his own subpoena said. And Mr. Richter had already stated that he had no intention of requiring the board to reproduce documents it had already produced. And Mr. Klinger says that the documents in Greene County were filed under seal. That's not true. They were submitted to Mr. Stafford in discovery. Now, Greene County says that those documents cannot be posted online on Mr. Stafford's Facebook page because Greene County has decided that discovery cannot be posted on his Facebook page. But that does not mean that those documents could not be used in this case. We could agree easily to allow them to use any records that the Board of Education produced in the Greene County case, to use those in this litigation as well. There's nothing that precludes us from doing that, and there's nothing that would preclude this commission from looking at those records. And Mr. Klinger says that we took an unduly narrow view, but the district has already produced over 2,000 documents to Mr. Stafford. Indeed, the bulk of Stafford's allegations in this case and the Greene County case are built on documents produced to him by the Board of Education in 2019. We knew what he was going to do with those documents when we produced them back in 2019. If we were going to withhold anything, that would have been the time to do it, but we can't because they're public records, as Mr. Klinger indicated. There's nothing I can think of that we did not produce from the February 26 order. I told Mr. Stafford's attorney that multiple times leading up to the current motion. And with respect to what other entities produced, I did not, maybe my language I used in my email was inaccurate, but I have no idea what Mr. Stafford has received from other entities. So there's no way as I'm reviewing these documents for me to withhold documents based upon what other entities provided him, because I don't know what other entities provided him. So I apologize now if the language I used was not accurate, but I did not withhold any documents based upon what other people provided him. Only documents that my Board of Education has already given him. I don't know what else that we could, I don't know any other documents that we could give him that we haven't already given him. Revised Code 3517.153 provides that upon refusal of any person to obey a subpoena, the commission may apply to the Court of Common Pleas for Franklin County for a contempt order. That is the only statute allowing any sort of sanctions for a non-party. And again, the Board of Education is a non-party. But the Board of Education in this instance did not refuse to do anything. It did the best it could with limited search terms and guidance. If the commission wishes to issue further subpoenas or orders or expand the February 26 order to include additional things, the board will again comply and do those additional searches. But there's absolutely no evidence right now that the board refused to comply with the commission's February 26 order. So Stafford's motion must be overruled. Thank you. I'll take any questions.
Okay. I may, but at this point, do any of the commission members have questions? Please proceed. Identify yourself and ask your question.
Ms. Justice, this is Mike Kreitz again. I just want to ask the same question of you that I asked earlier, Mr. Klinger. What efforts have been made since the February orders were entered by the executive directors? What efforts have been made since that time to confer and try to resolve the discovery disputes that obviously exist here?
Well, since the February 26 order, obviously we had to comply within the time frame set forth in that order. When we did so, and Mr. Klinger didn't like our responses, he contacted me to let me know that he did not believe that we were in compliance for the reasons that he's already explained to you. And I explained to him that I did not think that he was correct, that we've given him, I told him repeatedly, we've given him everything that we have. I don't know of anything that we have that we haven't given to him based upon the criteria set forth in the February 26 order. So it was really, other than there was really nothing else for us to say. He believed that we hadn't complied, and I really didn't see how we hadn't complied. And so I think that would be those emails that he attached would probably be the confer with counsel type of emails that you would be looking for.
Thank you.
This is Scott Norman. I have a question to Derek based upon what I've heard. You mentioned that the documents were filed under seal and they couldn't be used in this. And what I'm hearing from Ms. Justice is completely opposite, which is the seal was to preclude Mr. Stafford from posting this information online, but it can be used in this litigation. Is that true and accurate?
So thank you for the question, Commissioner Norman. I'm holding the Greene County Court's protective order that the Board of District filed with their motion, or sorry, with their response to my motion. And it says that Stafford and all respondents will be prohibited from disseminating any information and or documents that are obtained solely through the use of the discovery process in this case. And then it goes on, it lists specific, but including but not limited to deposition transcripts, interrogatory responses, and responses to requests for productions of documents, admissions, or subpoenas issued until further order from this court. That applies again. It says disseminating any information and or documents that are obtained solely through the use of discovery process in this case. That's not limited to just online posting. That's disseminating in any venue. It says any.
Ms. Justice, this is again Scott Harmon. You heard what he said. Were you counsel and a part of that order that was taking place in litigation in Greene County?
I absolutely was, and that's why I know that it wasn't under seal. The order indicates that that those documents cannot be disseminated to the public. But again, there's nothing in that order that would preclude us as counsel from agreeing that certain documents could be used in this matter, because the order limits it to things that are solely in that litigation. And so, we can agree that the documents that any public records that we're talking about here are not solely in that litigation, that they're also in this litigation. So we could easily come to an agreement, and that's what I was saying earlier. It would take nothing for us to come to an agreement. Oh, yeah, of course, those documents are relevant to this case. You can use those. The whole purpose of that motion for protective order in Greene County was to preclude Mr. Stafford from taking depositions and discovery responses and posting them on his social media posts. So using them for purposes of litigation obviously is different than posting them online. And so the parties could easily agree to that.
Thank you.
Anybody else? I have a couple of questions. Anybody else have, any other commission members have questions before I move forward?
Yeah, Phil, I'd like to ask her a question if I could. In Mr. Klinger's memorandum, he listed, and we've been talking around about this, 3 areas. The first area was documents the school district believed were already provided by other public entities. You addressed that. You said you never took it into consideration. I'm wondering, where did he get that at then? Why was that written?
Yeah, and that's why I apologized early on, because the very first response when he contacted me to say that we were non-compliant, or the very first letter that I sent to him when we were responding to the subpoena, I think I said something along the lines of, other than things that have already been provided to your client, we're providing what we have, and this is the only additional document we can find. And I think I probably inartfully drafted that correspondence, and I apologize, but I did not withhold any documents based upon things that other people provided to him, because there's no way for me to know what other people provided him.
Okay, the second was about the Greene County Court of Appeals, or Common Pleas. You already addressed that. You said he can have whatever information you provided to Greene County, correct?
Yes.
And then the third one was documents already produced pursuant to other subpoenas. What did you mean by that? Why did you exclude those?
And again, it was probably an inartfully, I am not aware of any subpoenas. I meant public records requests. And so because there have been so many public records responses, that I'm not aware of any additional subpoenas issued that I could, it was inartfully drafted, but that's why later I told Mr. Klinger, I've given you everything that we have. That's why later I followed up with, I've given you everything we have.
All right, thank you, Phil. That's all I have.
Okay.
This is Natasha Kaufman, and this is actually directed to Mr. Klinger. One of the things you said really has stuck in my mind as I've listened to both of you speak. You said you assumed that they had more information. And I guess I would like to have you maybe expand on why you would assume that, or what, where that came from, because that word is troubling to me.
Yes, and it's just two reasons for this. First, again, back last summer, my client placed records requests with the school district. They're saying he placed 200 records requests. It was actually 8 records requests, but they have multiple components, so they're kind of exaggerating this. But he placed 8 records requests back in the summer, and the district provided some documents, but in their response, they said that some things did not qualify as public records and that they were not providing them. So in response to that, my client placed records requests with other public entities, and it turns out that other public entities had public records that, based upon these, they were also in the possession of the school district and related to the levy. We're talking about emails from the PAC's effective campaign manager and the district superintendent to other public employees using their email addresses, and that's how this ended up. That's how these records ended up in the possession of other public entities. Now, the school district did not provide us with that information, even though we requested it. But then we went to other public entities, and these entities gave it to us. So based upon that, we do know that the school district did not give us everything, even though they're saying they did. So that's one basis of the knowledge, really, that we know they did not give us everything. The second is, as Ms. Justice stated, they filed discovery in the Greene County case under seal. I'm looking at the order. The discovery order from the Common Pleas Court actually says that discovery will be filed under seal until further order from this court. And so they file stuff under seal, and I've seen the records. There's stuff in there that they filed under seal that has zero relevance to the Open Meetings Act case and is quite squarely and plainly in response to the subpoena or the discovery in this case. So it seems to me that they're trying to hide it behind the discovery order that was issued in the Greene County case. So there are absolutely documents that they have not given us, and that's why I'm saying that.
Thank you.
This
And
is,
I apologize, Ms. Kaufman, may I briefly respond as well?
Yes, please.
So one of the things that he's talking about when he talks about they made a public records request to another entity, that entity was the Greene County Auditor's Office. And just so that you understand that that entity is not on the list from February 26th. So when it comes to that when he's talking about that other public entity, it is not on this list from February 26th that we were supposed to respond to. And again, we didn't file anything under seal. The order with Greene County says that if any documents from discovery are to be filed with the court, they are to be filed under seal. No documents have been filed. They have in fact been provided to Mr. Stafford and his attorneys. They have them. The only question here is whether or not they can use those documents as agreed upon by the parties in this matter. And I've already said that the board will agree that they can use those documents for purposes of this litigation. So thank you. I apologize if I answered both issues.
Thank you.
I have a follow-up question related to that. If that's the agreement that you can use them associated with this litigation, Mr. Klinger, what further action do you need from the school board to do that? Do you need an agreed entry in the Greene County Common Pleas Court to protect yourself from that? Or what are the parties going to do this seems to me to be a resolvable issue. You both agree, they've been produced, you have them, the school board saying you can use them, you're saying you're afraid that you're legally prohibited from doing so. So what do you do as parties, and what do we as a commission do to resolve that when it seems to me like there isn't a dispute?
Well, thank you, Commissioner. I've got 2 responses to that. First, if the school district will agree to an entry letting us use them, then that'd be fantastic. This is the first they've offered that. My motion's been out there for more than 2 months. This is the first time they've said this to us. And so that would be great. But there's still the second issue of the 10 subpoena requests that they've flatly refused to respond to. So they still have they've not even bothered attempting to respond to those requests. And so that issue is still out there.
Okay, I'm going to get to that in a minute, but I'd like to hear Ms. Justice's response to this, whatever's happening in Greene County and Discovery and the usability of it. How does that get resolved?
Yeah, and I think that if I've said it, it's a public record now, but if we need to put an order in front of and one of the resolutions, as I mentioned, was that the parties can just agree that those particular documents, Bates number, whatever through whatever, are not solely for purposes of the Greene County litigation, then that's all we would really need. But if it would make Mr. Klinger feel more comfortable, I'm happy to put together an entry that says Bates number through such and such, are not subject to, or either not subject to, or can be used for purposes of this this hearing that we anticipate having in this matter. I mean, whatever it takes, that's a easy resolution.
Okay. Then I also have a follow-up question, and maybe the commission can circle back on that when we get to decision time. Then I also have another question for Mr. Klinger. When Ms. Justice is saying that the issue is, as it relates to the Greene County litigation, certainly what was produced by the school because it was produced to you, I assume. So there's no question about what those documents are. We don't know, but you both know what those are, correct?
Yes.
Okay. So then my next question to you, Mr. Klinger, is Ms. Justice is saying, we did our search parameters through our emails. We got everything we can, and other than what was already provided to you in this litigation, which is known to both of you, this is all we have. Now, my question is, are you disputing that, or does there need to be a different parameter search? Or how can that get resolved other than, your speculation that it's not all that it should be?
Sure. And so first, I would say I don't think they have provided everything. What they're saying that they have provided are in response to just 3 of the 13 subpoena requests.
Okay,
I don't think they're responding to the other 10.
Okay, so we'll get to the 10. Let's talk about the 3 right now.
Yeah.
As it relates to those 3 and the responses that were provided, Ms. Justice is saying, we need direction on parameters. We search this, we search this, we search this. Other than what we already provided, we provided everything else that came up. I think as it relates to those 3, your comment was it was one document or a limited number of documents. I think there's more. So if we understand and believe what both of you are saying, my question is, what is it that you think the school board needs to be doing, or how do they need to change their search parameters, or what is it that you're looking for that they have not provided, and how can you give us all guidance on how to get there?
Sure. And so with respect to just those 3 subpoena requests, going into this, part of my concern was that Ms. Justice had said they excluded 3 different groups of documents. Now, today she has said that 2 of those exclusions were not actually excluded. And so that is nice to hear. We did not hear that prior to today. But with respect to what was provided in the Greene County Common Pleas Court action, now, if they're saying that everything in their possession has been filed in that case, then I will take them at their word about that. But the fact is, they filed it under this protective order. And so the problem is I can't use it because it's protected.
We understand that's going to be resolved, it sounds like. So given that position and given her saying we've responded to everything there is and given you the only other things, from my perspective, unless you can identify different search parameters or something that you think would indicate things and ask them to run it, I'm not sure I've done these computer searches before. They're not easy. You have to be kind of specific about how you do it. And, the data is stored the way it is. And so if there are things that you think would come a certain way, if she's disclosed the search parameters and what it came up with, If there are things that you think are there things that you think additionally should have been searched and how, and can you give us some direction on what that would be?
Sure. And so one thing, and it might have just been a typo on Ms. Justice's part, but in her affidavit she filed with her motion, she says that one of the search terms she used was, quote, the May 9th, 2019 election. Now, the election was actually on May 7th, 2019. So if that was a typo, then that's fine. But if she did in fact search a May 9th election instead of a May 7th election, then that's something that would need to be corrected. I also, the subpoena requests were narrowed by sender and receiver. And so if they're assuring me that they searched by sender and receiver, which I've not heard today, but if they are, then I think that would be fine.
Ms. Justice?
Yes, and so that and I apologize. I hear some feedback, but yes, it was May 7th. I did not actually remember. So it was May 7th, and levy and election, and so yeah, the terms I actually did. For whatever reason, when we were doing our response, May 9th got stuck in my head, and I apologize for that. But yeah, so and did two. It says sent or sent by or sent to, and so he had to do those searches with both to and the sender and recipient. However, the search block, he has to enter that information. So yes.
Okay, and when it was the to and from, it was the individual requested information on, so sent or sent to, and there was a list of A through M. So those names you would have done a search on the sent to for each one of those names?
Yes.
Okay.
And then on the second set, there's actually a list of sent by or sent to the following employees by any of the lists. So there's actually two lists in one category, two lists of names. And so we had to do, that one was a little more complicated because you had to do all of, so for instance, emails with Josh Bowles to or from Eric Clark, or all the emails from Josh Bowles to or from Eric Clark. So they had to do multiple searches on category number 2 in the February 26th order.
And was that done?
Yes.
Okay. Mr. Klinger, do you have any follow-up questions about that or how it was done?
No, I do not.
Okay. And I don't mean to dominate. Does any commission member have any questions about what we're talking about so far other than what I've asked? Okay. Then my next question is directed toward Mr. Richter, and it relates to the other 10 categories that were in the original subpoena dicus tecum that Mr. Klinger is saying they should have responded to, and I think Ms. Justice is saying we didn't have to because it wasn't in the follow-up order. So can you give us some guidance on the nature of those orders and how they are how you interpreted them?
May take me a bit of a time here.
Okay, we'll give you time. I'll yield to any other members who have questions and mute myself right now.
Yeah. I gotta find my orders. I apologize for my delays, but I'm working backwards through my computers here. Second quash. Everybody's just submitted to the commission.
Derek, am I allowed to address the commission?
I'd say no, not at this point. This is, it's between counsel, and that's all we want to hear from. If you want to talk to your counsel, you can figure out how to do so.
We want to take a 5-minute break while you look for that. Maybe Mr. Stafford and his counsel can confer.
Certainly possible. Mr. Klinger, help me understand, when you talk about the 10 other items, help me understand essentially what those are so I can try and do this a little more efficiently.
Yeah, so the subpoena, I'm trying to pull up my copy of the subpoena. I mean, do you specifically want the numbered requests?
I would like the numbered request, Mr. Klinger.
Okay,
I think it would be helpful, yes.
yeah. And this is, if you have the copy of the motion to compel that I filed, they're listed on page 12 in the bottom paragraph. The 10 requests are request numbers 1 through 7,
9, 11, and 13. Okay, thank
11,
you.
and 13. Yeah.
No, gotta go there.
While everyone's looking, Ms. Justice, do you have those categories in front of you that Mr. Klinger identified?
The original subpoena is actually attached, I believe, as Exhibit A. And so if you look, the requests 1 through 7, 9, 11, and 13, I believe, are the ones that Mr. Klinger is talking about.
Yes. And are you saying, I think you said that you were not obligated, your view was you were not obligated to respond to those. So my question is, did the school district respond to did the Board of Education respond to those 10 categories?
So no, we didn't. And the reason is we filed that motion to quash with the executive director. And then the executive director issued his decision saying it was ordered that we were to provide these following things. We had argued in our motion to quash that many of the requests from Mr. Stafford were far broader than the rules actually allow for discovery against a non-party.
Okay, thank you for that clarification. And I'll wait to hear from the executive director.
I apologize for the delay. Of all the things I did have open, the one thing I didn't have was the actual subpoena. And I'm trying to get it open. And it's taking its own good little time. Okay. One through 7, 9, 11, and 13. Smith. Well, relying on, the intro to every element in the Dukas Tecum that was provided by the complainant's counsel, that says excluding any public records already produced by the district to the complainant. My intent was to, I don't know if I want to say exclude those, because presumably they had already been provided, but still expecting that any other materials that have not been provided be provided to the complainant. In simple terms, I tried to identify the various people that were included either in some of the materials here in the subpoena, or subsequent emails back and forth that I saw between the parties as they were trying to work through this process themselves. So I based on where we are in all this, I'm not sure if that's responsive to your question, Ms. Cunningham, but essentially that's what I was trying to get everybody to do, was acknowledge what it was that had been produced already, and reflecting that anything additional that was out there based on those items, and he's talking about 1 through 7, 9, 11, and 13, that any other materials that would be helpful to the commission would be provided. That was my intent.
Okay, I'm going to try to inartfully summarize what I think you just told me. When you issued the February 14th order, it was an order identifying the discovery responses that were to be provided. And then after the motion to quash, when you issued the February 26th order, it was intended to narrow your original, keep in place your original order, but narrow it as specifically identified?
Correct. That's fair.
And that's what, it sounds like that's the way Mr. Klinger interpreted the order, but not the way Ms. Justice interpreted the order. Is that a fair statement?
That's probably fair, yes.
Okay, thank you.
Any other commission member have questions? I have a couple of questions for Ms. Justice, if no one else has any questions. Yeah, a lot of the discussion that we've had here is related to what has already been produced as a part of public records requests, the other suit, all of those kinds of things. First, my question to you, Ms. Justice, is as it relates to all this, how intimately involved have you been in the school district's production of materials from the time that the public records requests were first commenced here with this, which I appreciate goes way back, but I'm guessing that the school district that got you involved, so please I'm trying to get an understanding of that.
Yeah, so from the very beginning, we were brought in to review. So when they started making public records requests in the beginning of June of 2019. So we were brought in pretty early. We had to do all of these searches. Actually, we did much broader searches than what we're talking about in this particular matter, because the public records requests were very broad. And so we were brought in to review because a number of the issues were related to, how where do you how do you even do these kind of searches when the public records request is so broad. So we were brought in very early. I've been involved in going through the documents. Again, this will be the second time that legal counsel has had to go through all of. Now IT does the initial searches based upon the keywords and information provided, but then legal counsel has to go through and try to figure out what is actually responsive. So yes, I've been involved since the beginning.
Okay. And who was it that controlled production of those materials, either to Mr. Stafford or to any counsel involved in any of the matters? Was it you or was it the IT department?
I did it. So you'll see any of the public records responses are actually Bates numbered from the beginning. And so it all ultimately came to me. Okay.
Did you maintain copies of the materials that were produced as a result of all this?
I have both. I have all of the materials from all of the searches, which is a lot. And I have all of the materials that were produced.
Okay. In an effort to try and resolve this, how easy would it be for you to just take those copies that you have already maintained and provide those to Mr. Klinger as a result of this situation, and then have produced everything? I'll ask you that first, and then I'll go to Mr. Klinger.
As far as reproducing what we've already produced, I could email them back over to them. Again, they've all been Bates numbered. They already have them Bates numbered. So I can resend that file over to them again. Again, I didn't think that really was part of what we were supposed to do, but absolutely, it would take me no time. I could do it this minute.
Well, I'm coming at this from that perspective, just because some of the discussion around this has been, I don't know, I don't want to say a refusal, but not producing other materials that have already been produced. And there's a conflict between, has it been produced? What hasn't been produced? Should it be produced? In that manner. And now I go to Mr. Klinger and say, were that to be done, what is it that you believe would still be missing?
Well, it's the records that the school district has said are not public records. Again, I think back last summer, Ms. Justice took an unduly narrow definition of what constitutes a public record, and they told us they excluded documents. So the purpose of the subpoena was to get those documents that they excluded. That's why each of the requests have that lead-in saying, except for the records that were provided in response to public records requests, please provide X, Y, and Z. It's only because because of this game playing they're doing that we're here today. And so we're just trying to get a resolution of this.
Could you then give since you seem to have an idea of what it is that is being withheld or not produced, depending on how you want to say it, could you provide a more complete but a more exact list of what it is that you are wanting them to produce?
Well, yes, that's basically what's in the subpoena request. Those are the documents that we identified as them having said that they were excluding documents. So that's what's reflected in the subpoena request.
Ms. Justice?
And we've provided everything that we have in response to the February 26th order from the commission. You know, if the order is modified to include the other items, then we absolutely will comply, as I mentioned in my opening on this. You know, if the order is modified to include additional items, we will search for those items and provide them. But right now, again, I don't know what we haven't provided.
Can I just respond real quick?
Sure.
So she's saying that they've provided everything, but they haven't. Again, stuff was filed under protective order. So I don't have that for this case. Now, I understand because of this case, we're going to work it out, and it sounds like we're going to get it, but it has not been given to us for use in this case. And secondly, they've also not responded to these other 10 requests. So no, they have not provided everything.
Okay, thank you. Any other questions from commission members relating to Ms. Justice's presentation? And then we'll give Mr. Klinger, if not, then we'll give Mr. Klinger 5 minutes to respond. Hold on, looks like Mr. No, okay. Go ahead, Derek. You've got about 5 minutes.
Well, thank you again. And with these questions, they've addressed many of the points that I was hoping to talk about in rebuttal. But again, I think the main issue is that prior to today, the school district had told us they were excluding documents. Now today they've said they weren't excluding documents, even though they said they were excluding documents. We also have this issue of the fact that they filed documents and relevant only to this case in another case so that we can't use them. So if we're resolving that today, then that's fantastic. And so I think that maybe that would deal with the requested sanction to compel the production. But that brings up the other point of the fact that none of this would have happened had my client not pursued this motion. So I think sanctions are warranted. I think the school district should be required to pay my clients reasonable attorney's fees for pursuing this motion, because absent this motion, we wouldn't have had any of this today. Without this motion, we wouldn't have found out that the district really didn't mean it when they said that they were excluding documents. And we also wouldn't have resolved this issue of the fact that they filed documents in another case and a protective order that we can't use in this case. And then it also opens up the question of the other 10 requests. So none of this would have been dealt with had the motion not been filed. And so I'm requesting that my client, who's gone through great expense to get these documents, be awarded his attorney's fees for pursuing the motion. Thank you.
Okay, are you concluded?
Yes, I'm concluding.
Okay, thank you. Ms. Justice, just very briefly, if you have another minute or two.
I really don't have much else to say other than I told Mr. Klinger repeatedly that we've given him everything that we had. I don't know what else, you know, if my first communication was inartful, that's one thing, but I told him after that multiple times that I'd given him everything. And so, you know, with respect to sanctions, you know, I think that we put this all in our pleading, but really the only recourse, there's no attorney's fees sanctions available. 3517-109 applies to parties. The Board of Education is not a party. 3517.153 indicates that you must initiate an action in the Franklin County Court of Common Pleas for contempt sanctions. So, you know, obviously you could consider doing that if you believe that the board refused to comply with the subpoena. Obviously, I disagree with that, and as I mentioned before, I believe that we followed the February 26th order as it's written. And so, I would respectfully request that the commission deny the motion to compel, deny the motion for sanctions, and I thank you for your time.
Thank you. Okay, the matter has been presented to the commission members. I'll turn it back over to, you know, either the chair or you all, so we can discuss whether we want to try and, you know, issue a resolution now, or whether we want to, just, I guess you would direct me to write some sort of a motion or a response, or however you want, not a motion, but a memorandum of response, whatever. And so I'll turn it over to the commission members to open the discussion.
Phil, this is a case of first blush for me, at least as a commissioner. What authority do we actually have as it relates to a non-party?
Well, in looking at 3517-153, which is where our subpoena authority comes from, 3517-153B says the commission, that's a form of complaints. The commission or a member of the commission may administer oaths, and the commission may issue subpoenas to any person in the state compelling attendance of witnesses and the production of relevant papers, books, accounts, and reports. Section 101-42, which is the General Assembly's subpoena authority of the revised code, governs the issuance of subpoenas insofar as applicable. And then it goes on to talk about if we wanted to take an action to support, as has already been discussed, we would need to an action to support. Unlike which I'm sure you're familiar with, a judge just sitting on his bench and saying, okay, sheriffs go out and do whatever. In order for the commission's subpoenas to be enforced by a court, we have to start a proceeding at the Franklin County Court of Common Pleas and go from there.
Would you agree with Ms. Justice's position that we do not have the authority to issue sanctions on a non-party?
No, I disagree with that. Between the commission's rules, which lay out this meeting and how we go forward, and the commission's inclusion of the civil rules as it relates to the issuance of subpoenas, production of documents, all those kind of things, I believe we have the authority of the civil rules as well, because those are all contained in our within our rules as an adjunct to what our rules say.
So let me ask a further question then. If we're considering sanctions, do we need then an additional hearing? Because I would think that we'd need some discovery from Mr. Klinger as to the time expended and what his hourly rate is and what he is purporting to be reasonable legal fees to obtain these documents, if in fact we were to find the motion to compel would be appropriate.
I think potentially, I guess the answer to that is yes, at least in terms of establishing what the amount would be, correct? In the past, the commission has not often acted either in this kind of a manner or a similar manner. But when we have done so in the past and issued either like a finding for reconsideration and then issuing imposing a sanction of a sort of attorney's fees, we'll then take subsequent information from whoever attorney is at issue here, getting that information from them and including it in a subsequent order. And so at least we would need some sort of specific direction, yes. Whether it would require a subsequent hearing or not, depends, I think, on how the discussion proceeds from here.
Well, as I heard it, and it was based upon Commissioner Cunningham's questioning, it appears that Ms. Justice had a different interpretation of your February 26 order than both you and Mr. Klinger did, which tells me it seems that, at least as I'm listening to it, there needs to be further production.
Okay.
So I guess I would be inclined to grant the motion to compel based upon your interpretation of your own order and the fact that Ms. Justice's response to the request for production of documents was not consistent with what your order, the intent of your order, or the actual wording of your order.
Mr. Chairman, this is Charlita Tavares. I would agree with what was just shared. I think that we should compel for the additional information that's being requested.
So can I interpret that then, Mr. Norman, as a motion and Ms. Tavares as a second of that motion?
I'm
Well,
comfortable with that.
At this stage, I was just putting out my opinion. I wanted to hear what everybody else had to say before I actually put a motion before the commission.
Okay, understood. I'm just trying to clarify.
Yep.
Any other thoughts from commission members?
This is Catherine, and I think I agree with Mr. Norman. I think that we should order a response. And I think by identifying the paragraph numbers, as we've discussed in this meeting, is probably the most appropriate way so that it is clear to all parties. So to me, that would be paragraphs 1 through 7, 9, 11, and 13. And that includes not a reproduction of what's already been produced. I think I would add the thought that we should order the parties to come to an agreement relating to the use of the materials that they have a different interpretation of in the Common Pleas Court case, so that we do not have a discovery dispute here. I think they can do that themselves, either by mutual agreement or by agreed order in the court. That is beyond our jurisdiction, but to have them resolve it so that we don't have to and be in conflict with, potentially in conflict with the court of record, I don't think we want that. Personally, I am not in a position now to, I think, to make a decision on the award of attorney's fees. For me, I don't necessarily feel like we should deny that motion, but maybe stay that portion of the motion for future determination and not take any action on that right now. That's kind of where I am on it. And I would chime in, I agree with Mr. Norman. I think if we think that we want to go the sanction route, it does require an additional hearing, and we would have to receive evidence and information, and the school board would have to have the opportunity to oppose whatever they're proposing, and we'd have to make some kind of determination of reasonability, and Mr. Klinger would have to determine how he wanted to proceed on that.
I'll agree with that.
Yeah, this is.
Any other, I'm sorry, go ahead, Mike.
Yeah, I would agree with what Catherine and Scott have both suggested. I would go one step further, though. I think I would, in whatever decision we render, we give them a very specific time frame within which to go ahead and complete that. And also to the issue of attorney's fees, I think that we're going to have a discussion about that later, because not only we have to hear testimony, but then there's may very well have to be testimony as to whether or not the fees that are put forth are reasonable. But I mean, that's something we can discuss another day. But I would agree with the general format that's being laid out thus far.
Phil, likewise, I think I'm in agreement with what's been stated about the motion to compel. I think at this point, still a way to proceed. It sounds like we almost have total agreement amongst the commissioners, not yet, but.
It seems to be heading in that direction, yes.
Yes.
This is Natasha. I agree with what's been said. I think it's, it all deserves a little bit more time and research.
Okay.
I would have a question for Ms. Justice. You've obviously heard where we as a commission are headed, which is a motion coming up to compel. And you heard Mr. Kreis talk about a timing factor. I guess my question to you is, what kind of timing are you think you're going to need to now comply with this so that we can be fair to you? And when we put our entry on designating that you have sufficient time to do what you need to do?
As you folks know, the school districts are running, it's summertime, so we're running a little short-staffed, and so I will need some additional time. But on the other hand, and we're also trying to prepare for potential remote learning for all of our schools at this point. But if you give me, 20 days, I think that would be sufficient.
Yeah, I would be in favor of 30 days. I think 30 days is a reasonable period of time to go ahead and respond.
And I had 45 days in my mind, so.
I'd lean towards the 30 days.
Yeah, Mr.
So, I'm
Director,
sorry.
When is this case set for hearing?
It hasn't been set at this point. I am, considering how we have been away for a while, and that I'll get ahead of something Mr. Bromer and I talked about yesterday as it relates to talking about future meetings. Right now, I have us scheduled at the next commission meeting to actually meet in person here on July 23rd. Taking into consideration appropriate social distancing at 10 a.m. Right now, we only have campaign finance related cases on that were continued from April. I may put a few more things on, but it's going to be a relatively limited meeting. But anyway, I say that only to say, be aware of that. But we're getting back to meetings. I'm hopeful and thinking. I was anticipating having this matter addressed at some point in at a full hearing in the September-October timeframe. That was what I had in the back of my mind. I have not specifically said it yet, and so your respective discussions of timeframes, whether it's 20, 30, 45 days, I think would well meet within the parameters that I am anticipating for setting this matter for hearing.
And Mr. Klinger, would that be acceptable to you then? A 30 or 45-day extension to go ahead and comply? Would that give you adequate time then to go ahead and prepare for the hearing?
Yes, it would. And thank you very much.
I guess the next question I'll put out there to commission members, as we have discussed, is do you want to go ahead and make some sort of a statement today? Obviously, we're kind of heading in the direction of at least making a decision to support the motion to compel. Do you want to just make that as a statement? Allow me to, or direct me, I guess I should more say, direct me to produce something in writing on the commission's behalf that would lay out the timeframes. Anticipate doing that here in short order and getting it out relatively quickly so that there is sufficient time for everybody to work with that? Or did you want to try and do it just here, as we're all convened and putting it in, essentially putting it in a statement that would be contained within this video?
I think it does, if we put it in writing, that way the parties have it directly in front of them. I think we should delineate specifically which portions of the subpoena that they are going to be required to respond. I think we should specifically put in the time frame of 30 days to respond. And I also think that we should put in this particular order how you're going to address it, that at this stage we are going to put a stay on any type of sanction, which is subject to redress, but also subject to further discovery as it relates to potential fees and the reasonableness thereof.
I would agree.
I agree.
I agree. And I think, Phil, you can draft something and circulate it among commission members for comment before it's issued by the commission. I would suggest that so that we all have the opportunity to look. I see Ms. Justice scrunching her brow.
Well, only because we're currently subject to Open Meetings Act case against us by this exact person. Sorry.
Well, from my perspective, we're, when we have a quasi judicial hearing on a motion, it doesn't require a public meeting for us to review the materials and have the executive director issue an order on behalf of the commission that reflects the oral motion and decision made. If there is an objection to that, let us know. But I think as commission members, we have the right to do that without in violation of a sunshine law, as long as it is a memorialization of an oral motion and decision. So if there's an objection to that by either council, please make it now, but that's sort of my view. And I think members can expeditiously review it to make sure that it is adequately memorializing what we're going to orally decide today. And I welcome anybody else to chime in on that.
I would move that we proceed as I had just outlined.
Phil, I wonder, should we also include in this document the common pleas issue?
I think Ms. Cunningham addressed that earlier. I think that and Catherine, please, after I get done, comment. I think that to me, what we should do is include in our finding that we're directing the parties to reach a resolution on that particular issue that they can mutually take to the court to allow the court to allow the production of those materials for our purposes.
Phil, from my perspective, I think we would ask the parties to reach a resolution and submit to the commission what the resolution is. I don't think we can direct them to do whatever they feel is appropriate with the court in proceedings that we're not a party to or a member of. But I think that if they can reach their if we can order them to submit something to us that they both agree is adequate. And I think that's the more appropriate approach.
Explain that to me again. I'm trying to jot down here.
Well, the parties have represented to us that they, can come to a resolution as to the use of documents produced in a different proceeding. So I think at least from my perspective, any motion or order of this commission would be that they provide to the commission memorialization of that resolution, whatever it is, whether that's a mutual agreement between the two of them or an order that they choose to get from common pleas court. I feel like that's up to the parties. They've represented that they can come to resolution on it and it's not going to be a dispute. I feel like it's up to them to decide how to do that and submit to us the memorialization of what they feel is appropriate so that they can share documents, and then it's on them. I don't think that the commission is in the position to order them to go to common pleas court and do something in litigation that we're not a party to.
Okay. Yeah, I'm with you there. I was just wondering exactly how you were looking to phrase that. That's why I didn't want to say we were ordering them to do anything. But hopefully they will be able to reach a resolution and then provide to us that they have done so.
I think we can order them to submit the resolution to us, so it's part of our records. But beyond that, I would hesitate to get involved in how they choose to work that out among them.
Okay.
When pending litigation in a different forum is at issue. And I welcome input from others.
Okay. Well, I thought I heard Mr. Norman move, and what I would ask you to do again, Scott, because we're kind of working here, and I'm trying to jot down notes, and don't know how effective I'm being. Please restate the essential basics of your motion so that I can then prepare an appropriate writing based on that.
I would move that we ask our executive director to memorialize in writing that we are compelling the production of documents. I believe the motion to compel should specifically delineate the line item or numbered items in the subpoena to which we believe a response is required. We have also designated that we are going to, by agreement of the parties and discussion through everybody, that they will have 30 days to respond to the motion to compel, and that we are at this stage going to stay any determination as it relates to sanctions, leaving open that if we do address it, we know there's going to be additional evidence needed and a hearing conducted as to the necessity and reasonableness of any type of sanction.
And I would second that. This is Charlita.
Okay. Any further discussion on the motion that is currently before the commission?
I suggest a couple things. One, that the 30 days be from the date of the issuance of the written order of the commission, so it's clear when that starts running for the parties. And then I would also suggest that the parties be required to submit to the commission their mutual resolution of the evidentiary issues relating to documents previously produced in the common pleas court case.
I would move that those be added to my recommendations.
Mr. Tavares, are you? Thank you.
I would second.
Okay. Okay. Yeah, I was going to suggest that as well. Thank you, Ms. Cunningham. Are there any other comments from commission members before we move to a vote?
Mr. Richter, did you want to schedule the trial date now in this order, or that's going to be issued by separate order? And do we need to check with the parties to see their availability? I don't know that it needs to be part of this motion. I just throw it out there.
Yeah, I would prefer not to do that at this time because it's still, we're still in flux as it relates to what we're going to be able to do, much less everybody else. And so I'd prefer to hold that in abeyance and let me just work through the parties. So I certainly wouldn't schedule something that, Mr. Klinger, Ms. Justice, and whoever else couldn't make. I will work with the parties on that. So, I mean, we worked through the first time when we were coming up with the April 30th before that went away. But that was totally outside of their, outside of their control.
Thank you.
Is there anything else? Does anybody else want to add anything before I request each of the commission members to vote on this matter? Okay. Having said that, there's a motion before the commission to compel, to essentially support the motion to compel production as reflected in Mr. Norman's statement, seconded by Ms. Taveras. Ms. Cunningham.
Yes.
Mr. Kreitz.
He's on mute.
Yes.
There you go. Mr. Beatty.
Yes.
Ms. Kaufman.
Yes.
Ms. Taveras.
Yes.
Mr. Norman.
Yes.
Chair Bromer.
Yes.
Okay. This matter is then concluded as it relates to this motion. And pending anything else that the commission would like to discuss while we're in session, which should be limited. This meeting is essentially adjourned, but it is not. I will allow the chair to do that. Is there anything else the chair would like to say at this point?
Nothing that I would like to say. Does anyone else have any comments? Anything else? If not, I'd entertain a motion to adjourn.
So moved.
Anyone?
Second.
Okay, Mr. Norman has moved to adjourn. Mr. Kreitz seconded. I think we'll just take a voice vote here. All in favor signify by saying aye.
Aye.
All right, I think we are adjourned. Thank you very much, everybody. Mr. Klinger, Ms. Justice, thank you very much as well for your very productive information. Thank you very much. And you will be hearing from me as quickly as I can get to it. And yeah, it'll be 30 days from the date that is issued, and a date will be included on the order.
Thank you so much. Thank you, everyone.
Not a problem. Thank you.